matter PMC and a local health board.
Yes, good morning, Mr. Weir. You're presumably going first?
I hope so, my lord.
Yes. Well, before you do, let me just say something and see if that affects anything. Obviously, we're very grateful to all for putting in such comprehensive and useful submissions, particularly to the advocate, to the court. And we have noted Ms. Green's statement of paragraph 87 of her submissions. And I'll read it out so you don't need to get it. It's suggested that this court may wish to await the Supreme Court's decision in Abassi before handing down judgment, given that the appeal concerns the nature of evidence required to justify a departure from open justice in cases which involve a re-S balancing exercise of Article 10 and Article 8 rights. The Supreme Court's decision may well be pertinent to an issue in this appeal, including what sort of evidence a child or protected party must deduce in relation to potential future risks if they are not granted anonymity, and whether the Court of Appeal in X against Dartford was correct that evidence as to specific risks was not required. Now, we've had a conversation about this, and the court is concerned that if we proceed with the argument in this case before we have the Supreme Court's judgment in Abassi, we're going to need either to reconvene or at least request written submissions. And we know what happens. What happens from experience is that then there are response submissions and further submissions, and things become confused after Abassi is available. And experience tells us that we would have been so much better if we just waited until we had Abassi, got you all to rework your submissions on the basis of Abassi, and then had the argument. So we feel, subject to what all of you may say, at the moment, is that it would be more satisfactory for the argument to start once we know what the Supreme Court is going to decide. We've also reconsidered the question of whether the official solicitor and the PIBA ought to be asked to make oral submissions, having seen their very helpful contributions. And we think, subject to what submissions again may be made this morning, that that would assist the court and that we should ask them to do so. So in those circumstances also, we are very doubtful that one day is going to be enough for the argument anyway. And we think that 2 days would, in the new circumstances of all the helpful submissions we've received and seeing Abassi in the Supreme Court, be a more reliable estimate. So the worst of all possible worlds would be to have an argument today which gets halfway through. We're very interested in it, but we have to adjourn for 6, 8, 10 weeks to come back for more argument. That's the worst of all possible worlds. So I'm afraid that all adds up to, subject to submissions that you're going to make, and I'm sure you're going to tell me you want this appeal decided quickly, and so do we, by the way. We would be minded to adjourn to a 2-day fixture after Abassi is available. The only question, of course, is when that will be, and whether delay is something that is of such concern, either in this case or in other cases, that we should take a different course. Now, I've made inquiries, and I don't have any, I can't say when we'll get Abassi, but I have decided effectively that we should take a risk and list this case for the summer term, for a 2-day hearing, and assume we'll have Abassi, It will by then be over a year since the argument, and I'm hopeful that that will be realistic. If not, well, we can all come back immediately after Easter for a directions hearing and decide what to do. We probably will know a bit more by then. So that's what I want to hear your submissions on initially. I know it'll be disappointing news, and I know it has cost implications, but we only got Miss Greeny's helpful submissions on Friday, and there really is a lot of material now, and rather more counsel than appeared before Mr. Justice Nicklin, I note.
My Lord, yes. Well, my Lord, I appreciate that in the face of those observations from the court, any attempt by me to encourage the court to hear the case today may be an uphill struggle. But can I try, if only briefly, before...
Never an uphill struggle with me, Mr.
My Lord,
you know that.
Of course I do, my Lord. I'm so grateful for that. But, my Lord, I think from the claimant appellant's perspective,
yeah,
I would make the following submissions. Abassi is a case which involves the parens patriae role or jurisdiction, if that's the correct word, of the court. This is not. This is a case which proceeds as an ordinary case in civil litigation. We accept and recognise that at the outset, and it was going to be one of my early doors submissions to the court. So I am not seeking to invoke the parens patriae jurisdiction of the court and the guidance that the Supreme Court gives in relation to that in Abassi will not at least directly apply. I am not...
Well, what if the question in this case, according to your notice of appeal, is all about jurisdiction?
Two issues, my Lord, yes. Jurisdiction and whether the learned judge respectfully was wrong.
Yeah, I understand that. But
Yes,
the primary issue is jurisdiction, and that is precisely the question of jurisdiction and cuja, and is all in issue in Abassi.
My Lord, I had, wrongly as it happens, anticipated your Lordship saying to me, I've just given judgment in Tickle. I don't suppose you've benefited enormously from my skeleton argument to remind you of that, because we didn't have...
I did remember.
I think your Lordship remembered, but we didn't know who would have on the bench, so we thought we'll put that in anyway. And in that case, as your Lordship recalls, your Lordship identified Section 6 of the Human Rights Act, what I would describe as and/or Section 37, without needing to get into that at this stage.
We didn't decide that. We just said if there was jurisdiction, that's where it would be.
Yes,
very likely.
Yes, my Lord. The case failed for, I think, at least three on at least three bases.
Yeah.
But your Lordship was, if I could use this language, entirely comfortable with the proposition that there was jurisdiction under the Human Rights Act, and coupled with, if necessary, Section 37 of the Supreme Court Act 1981, so that I had anticipated your Lordship saying to me, well, whether or not there's an inherent jurisdiction of the court to make a reporting restriction order, which I may end up shortening to RRO, matters not, Mr. Weir, because we can all see that we can apply the HRA, if necessary, coupled with the SCA. There's also the separate issue of the Contempt of Court Act, which I'm fully expecting to win on, but I haven't yet understood a proper response to the submissions I'm proposing to make on that. But we'll come back to that. But it doesn't matter for these purposes, because Lord Reid in A and BBC says whether you are looking at this under the inherent jurisdiction of the court, or whether you're looking at this through the lens which Lord Stain so keenly encouraged in the earlier case of In Re S, matters not, because the essentials of the balancing exercise to be performed are the same. So that actually I was anticipating, my Lord, that your Lordship would say to me the real issue is whether or not the learned judge below was wrong in his holding that there shouldn't be what I'm now describing as an anonymity order, meaning a withholding order coupled with an RRO. That's an anonymity order for my terminology purposes, that there shouldn't be an anonymity order in this case. I was then going to make these preliminary submissions to include that as informative as the other submissions have been as regards what I would describe as the landscape in which the court is operating. I am not making a submission to the court seeking to echo the case put, in fact, by the official solicitor herself in her written statement to the effect that there should be a general rule in favour of anonymity for protected parties, starting at the outset of proceedings and continuing apace from there. I'm not making that submission to the court. Nor is this court strictly concerned today with Exton Dartford NHS Trust. I understand that this is always a matter for the court as to the extent to which the court chooses to provide guidance, obiter dicta and such like in relation to something.
But the problem with that argument is that the judge said quite a lot of things about Exton Dartford. One might perhaps be forgiven for thinking that he was bound by Exton Dartford.
Yes, my lord.
But he says some things which at first sight seem to cast doubt upon the approach, and we are asked to consider what should be the normal position in the various drafts that have been put forward. And so, whether we want to or not, we are going to have to look at Exton Dartford, and not to look at Exton Dartford in the light of the jurisdictional foundation of a really significant case like Abassi, albeit in a different context. But all these cases are in different contexts. So, I can say to you, well, Tickle doesn't help or indeed hinder you or anybody else because it's such a different context, and we were not deciding the jurisdiction question. What we were deciding was whether the judge should have done what he did in relation to anonymity of judges. But unfortunately, these cases come again and again, and I, for one, would like to get this issue resolved. I don't say once and for all, because that's would be arrogant and impossible, but I'd like to get it resolved, pro tem at least, in the light of the current law. Now, we know their lordships are thinking long and hard about Abassi, so
Yes.
we can expect, can't we, that they're going to tell us what the law is, because that's what they currently customarily
my
do.
lord, yes and no, in the sense that there's so much Supreme Court jurisprudence to the effect, absolutely clear, crystal clear, in relation to the court has a jurisdiction, at least under the Section 6 and or coupled with Section 31 of the Supreme
Section 37.
37, my lord, to provide an RRO, that it's difficult to conceive that this Supreme Court is going to go behind that the law is established, long established in relation to this. Multiple of these cases involve...
There are different emphases, aren't there, in A and the BBC and Cuja, for example, and Re-S, which may actually be elucidated. I mean, Lord Burnett in Abassi said certain things which are being challenged in Abassi and would be relevant here. I mean, this is what bothers me. So two things bother me, really. One, we have one day, and we've now got, if I may, without being rude, we've got loads of interveners from whom we would like to hear because they've got important things to say. Two, we're being asked to set out a blueprint for the future in terms of what should happen in these cases, bearing in mind that X was 10 years ago now. And should we not do that? And we're going to, if I accede to Ms. Green's submission and we hear argument today, we're still not going to give judgment until we've heard from Abassi, and then we're going to have all the toing and froing. What I was planning on asking everybody to do was to read Abassi when it comes out, revise your submissions, put in one submission each, knowing what everybody else was going to say today, a completely replacement submission, and then we'll start the argument from a position of knowing what everybody would like us to do. and we won't have that. I mean, look, you and I have been in this game a long time, Mr. Ware. We know cases where the argument is sort of stop and start, and then somebody puts something else in, and then another case happens. It's not as satisfactory as having an adjournment.
From the claimant's perspective, it's trying to say what is actually not, in this sense, before the court. I understand, and the example can be given of the Churchill case, which your lordship will recall was a case actually about the pre-litigation defendant's own internal complaints procedure, but became a case about the appropriateness of an order for compulsory mediation because the judge below had held, by reference to the case law in relation to mediation, what the outcome should be on something that had nothing to do with mediation, but with pre-litigation complaints procedure.
And that would be jolly useful.
Well, Lord, many people have been very delighted that that matter's been clarified, not least as I recall two people standing just here who are thrilled, who hadn't made an appearance, as they themselves said, for 2 decades or something such. That's fine. But in this case, my Lord, there are approvals going on in the courts every day.
No, completely get that.
No, but my Lord, the point I'm seeking to make, is that an appeal can be made from one of those cases every day at the moment. What's happening, and I did this, I don't know, a week or so ago, is I had to spend 15 minutes persuading the learned judge that PMC had not altered the law that is Exton Dartford. The law that is Exton Dartford, strictly speaking, is not before this court, because I am not making an application for anonymity after settlement of the case and with a view to approval. That is not before the court. And so it isn't my submission that this court needs to understand, and in a more broad personal injury context, delighted that this court is seeking with open arms to address matters of great importance to personal injury practice, but it's not actually before this court. And I had in mind making a submission that obviously with all the power vested in this court, whether it's by way of a working party, a rules committee or such like, it can, or waiting for or encouraging another appeal, a case dealing with that specific issue can be put before the court. For now, Exton Dartford is as much binding on this court as it's binding on Mr. Justice Nicklin. And so we simply take Exton Dartford as a statement of the law. Indeed, the exposition by this court of the appropriate way to approach an issue of an anonymity application in what I describe as ordinary, meaning we're just in civil litigation, we're not in court of protection, we're not in any special jurisdiction, we're in the King's Bench Division litigation, may itself prove to be of value to the Supreme Court when considering its judgment in Abassi, which is obviously, as your Lordship has observed, pondering over.
I think we have to assume that they're not going to, if we were to get a judgment out by Easter, that by that time it'll probably be done and dusted. I mean,
your Lordship knows far more about the internal workings of the Supreme Court than I do, but there is no reason in principle to think that a judgment from this court might not be of benefit to the Supreme Court. In other words, turning it the other way round. So, my Lord, for those combined reasons, we won't seek to repeat.
okay.
We urge the court to proceed today.
Okay, well, I completely get that. Now, who wants to go next?
I'll go next, but I'm not going to make any submission. I've heard what the court has said, and our position is adjournment is inevitable now, and that's what we should proceed to do.
Thank you. Ms. Greeny.
Yes, my lord. I think the court's proposal to adjourn, as opposed to my proposal of awaiting the outcome of the judgment in Abassi, is more sensible and streamlined for all the reasons that your lordship has articulated. So I would submit that seems very sensible. And then just 2 points in terms of what Mr. Weir has said. The first one is that I do observe, his first 1.1, his ground of appeal is a challenge on the jurisdiction, so which does, as my lord has said, engage the issues in Abassi. Because as I said in my written submission, there are 2 points from Abassi that appear relevant to this appeal. The first one about the jurisdiction arising from the inherent jurisdiction, and the second one that when it comes to the re-S balancing test and the derogation from the open justice principle, what evidence and what sort of evidence the court should be provided with in order to be satisfied with example, that the Article 8 rights or whatever rights, other convention rights relied on, outweigh the strong presumption of equal justice and also bearing on Article 10 rights. So it's on both of those matters. So, which leads me to the second point, which is even to, if the court were to go down the route of hearing this appeal on the basis that the relevant jurisdiction is Section 6 of the Human Rights Act combined with Section 37 of the Senior Courts Act, the next step is obviously the carrying out of the exercise of the derogation on whether the learned judge was wrong about that. And then that does directly engage the issue that arises about the nature of the evidence, because it's clear from the appellant's grounds of appeal that certainly some of the evidence they seek to rely on is of the more generic nature, which obviously brings into play what Lord Burnett was saying in Lord Justice Burnett in Abassi.
And if we do lay down principles of the kind of evidence that is appropriate, we want to do it and be seen to be doing it on the basis of the current law.
Yes.
Not on the basis of what we hope the current law might be or expect the current law to be. I mean, because the Supreme Court, being entirely polite about it, do have a habit sometimes of changing the current law when they consider cases of the importance of Abassi. So, I mean, what I don't want to do is predict wrongly and then find we sentence this case to going to the Supreme Court when otherwise it wouldn't have been necessary. It would be regarded as a procedural matter based upon the current law as we are informed it is by the Supreme Court. So, I mean, that's the way I see it. But, okay, well, thank you very much for that. Now, who else have we got? We've got Mr. Toyne.
My lord, you don't have Mr. Brown for the BBC. You don't have Miss Scott for the official solicitor. You don't have.
No, we do have Miss Scott for the official solicitor.
Oh, I'm sorry.
I've come in while you were speaking.
Why don't you come a little further forward so that we can hear you as well as see you, Miss Scott?
Yes.
First of all, I want to apologise to you for giving you such ridiculously short notice. That's entirely my fault. I sent a note to my clerk yesterday asking her to contact you, but she understood that it was a note to my colleagues, and I never. It's my fault. I never said to her, "No, please contact Miss Scott." But you're here.
I'm here. A little late, but I'm here.
But you didn't hear me say that one of the reasons why I think we probably should adjourn it is not only the fact that we don't have Abassi and we'd like to hear argument on Abassi when we do have Abassi, but also that we would prima facie like oral submissions both from the official solicitor and from the PIBA.
Thank you, my lord. My instructions are that the official solicitor thinks that the suggestion of an adjournment is a sensible one. The only point that I make is whether or not the court can do anything to make it clearer in the interim. And I hear what's been said that the Derbyshire case is not before this court. But
what about this? I don't think we can say how we're likely to dispose of this appeal or really introduce clarity. But what we could do is to list it for the first available date in the summer term and indicate that we'll give judgment quickly. We're seized of it. Hopefully we'll be able to convene the same court. So that everybody will know that all being well, they'll get a definitive judgment in, say, May, which is only 3 months away, really. I mean, and you've waited already quite a while.
Yes, yes. Yes, I don't think I can say very much more, other than the point is being made that the court's being made. I don't know whether this court might be able to say something that the Court of Appeal judgment in the Dartford case still stands, and that lower court should be following that in the interim because of the confusion that has arisen.
Well, I think we can say that a first instance judge cannot overrule a Court of Appeal decision, I would personally consider myself bound
Does that really
by
need to be said?
Dartford.
Indeed, it doesn't need to be said. One just needs to articulate it to realise it doesn't need to be said, but in practice it is causing, as I understand it, real difficulty.
Well, in practice, for the time being, I think we can say what is absolutely obvious, which is that first instance judges are bound by Dartford. Even if it were challenged here on whatever grounds, I can't imagine why we wouldn't be bound by it. But even if it were challenged here, we haven't decided this case yet.
Thank you very much. I have no further submissions to make.
And this is open court and being live streamed. Good. Now we've heard from everybody. Mr. Tyne's not here. You see.
There's Miss Formby of King's Counsel is current chair of PIBA and she's in court, my lord.
Right.
My lord, I'm not rogue, but I have been here throughout. I'm not rogue because we were not.
No, you're owed the
asked
same
to
apology that.
Or submissions, but I was here to attend. If I may address you.
Of course you may.
Undressed,
Yes, of course you may.
I hear the benefit of the adjournment, and PIBA would support that, would bring clarity. The only 2 points I would make is, while on the one hand you would think that JXMX is binding as a Court of Appeal judgment, you may have noticed the Supreme Court, the White Book notes that came out in January, have a little article about the PMC judgment, which ends by saying that the very least that needs to be done is the PF10 and the order that is set out by JXMX needs to be addressed and changed and cannot be relied on, which it's an unattributed article but gives an indication of the consternation that has been arising in courts. And as my learned friend Mr. Weir indicates, there are many approval hearings. The PMC was the end of December, and in the short time since then, we've been gathering information of what's been happening. Almost every court has been adhering to the JXMX process, so to speak, for want of a better description. But there are really concerning instances of cases being having submissions made, having new orders made, sometimes courts sitting in private, sometimes new orders being directed, and there already being a stretching of the seam, so to speak. So certainly we would welcome what may seem like a self-evident statement that until this court has made a further ruling, the current position, as stated by the Court of Appeal, should remain, imperfect as it may turn out to be, simply with a process of continuing jurisdiction until that time.
Can I just say this? Given the extent of your membership and also that of the PNBA too, I mean the two associations that really are going to have as members people who are going to be in front of the court on approval hearings. If my lord the Master of the Rolls thought it appropriate to say something today, could that not be circulated immediately, both amongst the PIBA membership and no doubt you can contact the PNBA?
Yes, I mean it was my intention to make a report to all our members today anyway, and I can certainly do that. Within the Master's Corridor there's already been a helpful statement that they will adhere to JXMX until there's any other ruling made by the Court of Appeal, and that sort of message disseminating out, and certainly I can do that. I will also contact the chair of the PMBA and ask them to do the same thing.
And I think it will be useful if we do adjourn this to have further thought given to what we should say ultimately in our judgments. We'd like to get submissions on all sides as to what process should be followed, so there is no uncertainty in the future. There may be a little uncertainty. I'm disconcerted to hear about the White Book reference.
It arrived on my desk yesterday afternoon.
Is it in our bundle?
No, I mean I literally received it about 6 o'clock last night. I found it in my postbox. You know the insert you get in the Supreme Court.
Yes, I do.
Of the White Book News. It's dated January. I only received it yesterday. I didn't bring it actually. I should have brought it.
It's the January insert.
January update.
The
yes.
problem with those, I hate paper, as is well known in this court. and I get those paper updates, and I do read them against my better judgment. Then I throw them away, and I suspect I may have thrown them away. So if anybody is better off than me and has that insert, if you could send it electronically.
My lord, I can do that. I
In
certainly
the next
have
few
to
minutes,
do
that
my
would be a
best.
help. Okay, thank you very much for that. Mr. Weir,
My lord-
do you want to say anything in reply?
Well, not so much in reply, my lord, but you can see,
Sort of reply.
see what's going to happen, my lord. And I understand that we're an open court and it's being live streamed, and Chair of PIBA has kindly indicated she'd take the steps she would. But it would actually invite the court to make a short written judgment. I appreciate how busy this court is, although it's now freed up most of the day to turn to other matters. But actually a judgment setting out what is happening in relation to this appeal, perhaps referring to the January insert and making clear the rule of precedence.
Well, I think it'll be a short oral judgment.
Yes, my lord.
I
Short,
don't see.
even a short oral one, my lord. I think.
We're still capable of giving oral judgments, even though we don't customarily do it. I think that will be enough. But what I'm going to do now is to rise for half an hour
Yes, my lord.
and sit again at 11:30 or so soon thereafter, as counsel can be heard, as we used to be allowed to say. And then I'll say what we're doing with the appeal and give a short judgment, and we will consider whether it should be written or oral.
Yes, my lord. I would still invite it to be written. It'd be so much more convenient. But it's a matter of course for your lordship, for the court.
So I have to give written judgments on adjournments now, yes.
Well, sorry, my lord, to draw you down to.
They can be
that.
transcribed, you know.
My lord,
AI is very good at transcribing judgments.
Well, I don't know. It might add something in, my lord.
All right. We will resume at 11:30.